Good afternoon. A very warm welcome from rainy England. We hope you'll hear us all right because the rain is really strong this afternoon, and to the extent that I've worried it will affect the sound. Thank you very much for joining us today. This is a super urgent webinar intervention following the final release of the judgment in Interdigital versus Lenovo. We have all waited a really long time for this judgment, and we thought this would be ready basically in September. And I was like saying, yeah, this is our September event, and it never happened. And then I somehow thought, maybe it'll never happen, who knows? But now it's out, and we are all really excited. And we have a new position, a new opinion from the United Kingdom on how to think about Frand. And I'm extremely honored. We have a great panel today. I can hardly think of anyone who's more qualified to talk about it than Sophie and Luke. If you laugh like that, I can't be serious. So Sophie and Luke and Miles from Bristol, who run the patent and the competition group in Bristol, also here in London today. So yeah, so Dr. Sophie Lawrence is the head of the competition group in Bristol. She has massive experience on Frand. She has been on cornerstone cases, including representing SETI against in the Supreme Court, the United Kingdom, in Unwide Planet, and also representing Samsung in key case. So I think she's done a lot on this area, and she's really, really knowledgeable, and she's also worked on both sides. So I expect a very fair representation. Luke Monda is senior associate with Bristol, has a background in computer science and law, double background, and has worked on all of the cases basically that I know of, and I really enjoy your very, very dry comments with a sense of British humor on what's going on in England. And Jeff Miles, who will hopefully soon be here too, is the co-head of Bristol's patent team. He also is one of the editors of Kluwer IP Law and has been so kind to edit lots of my thinking and publish that. And for those who don't know us, we are Oxfirst Limited. I'm Roya Garfele. Oxfirst has been launched 12 years ago now out of Oxford University. We are Oxford and London based, and we have a keen interest on all aspects, economics around intellectual property and competition law. And we work as experts in court proceedings and cook up random numbers, which we're trying to sell to be found afterwards. We also run a conference, and we hope you will join us. The conference is June 20 and 21 in Brussels. It's the 8th Intellectual Property and Competition Forum. We expect key figures in the world of IP and competition to be there, including Lord Justice Arnold, who I believe also signed up for this event today. Thank you very much. Dr. Patricia Rombach from the German Supreme Court and from the Unified Patent Court, representatives from the Brussels policy scene, from the UK policy scene, from the Swiss policy scene in IP. And also, from what I recall, we also have now support UK policy circles as usual. The IPO has been very, very kind to give a lot of new input and ideas. And I have already off the record debated with many people this judgment. Without having had a lot of time to read it yet, I personally have already an opinion. So now that we have got the time to talk about it for at least an hour, let me start by asking the first question. So how do you think, where were we before the judgment in terms of Frand in the UK? Where do you think this is heading?
Well, first of all, thank you so much, Roya, for having us. We're, like you, very excited to read this long-awaited judgment. And I will answer your question in a minute, but I have to very tediously give a quick disclaimer. You very kindly alluded to the fact that we act on both sides of this debate, and we hope that for that reason we're able to give a reasonably balanced view of what the judge has found. But please, for everyone listening, these are our personal comments. They're not to be attributed to any particular clients, past or
They're also not the comments of Oxford, of myself, of Oxford, of anyone. They're not necessarily comments of the speakers either. It's usual disclaimers.
Yeah. Anyway, with all the tedium out of the way, you asked about where we were. We just thought, I mean, I'm sure that we know the audience is very knowledgeable, but just to place this in context, in the UK, the leading case has, for a number of years now, been the Unwired Planet case, as that was the first case in which the English court showed that it was willing to determine the full terms of a Frand license. It did that on a global basis. Mr. Justice Birth, as he then was, reached the view that there was a single point for a Frand rate for that portfolio, as well as determining all of the other terms. And just as a reminder, because we're going to talk a little bit about the rates that were offered and determined in this case, the rate that he reached, the benchmark rate for the 4G portfolio was 0.052%, which equates to roughly 10 cents a unit on a $200 phone. So that was back in 2017. The Court of Appeal then was asked to look at the case, in particular, not so much from the point of view of the rate, but more from the point of view of whether global Frand was an acceptable thing for the court to be determining, and in particular, then to say, well, we will issue an injunction if the licensee doesn't take the rate. And the Court of Appeal and then the Supreme Court upheld that approach. The one change they did make, and we were quite interested to see how this would play out in this judgment, was to say that while they understood why Mr. Justice Birth had determined that Frand was a single point, actually it was more correct as a matter of law, and I think also economics, to say that Frand is in fact a range. And as a bit of a spoiler, in fact, the range point doesn't really come to life in this judgment. Following on from that, the Court of Appeal, that case went to Supreme Court. It was joined with the Conversant case, where, as you say, I had the pleasure of being part of the team acting for ZTE, along with Luke and Miles, who will hopefully be able to join us soon. And the court there focused on some of the jurisdiction and forum issues, and upheld essentially the point that the English court could determine a global Frand rate. Had some interesting things to say about how other courts around the world might approach this issue, which is something that has then come to life further over the years that have followed. And then, yeah, so I think you were going to mention a couple of the other cases that lead in
from
the
smorgasbord of other cases, where you've got your IP.com cases, the Philips cases, the Sysfel cases, the Vestel cases, the IP Bridge cases. One has to be careful not to leave anyone out. Wouldn't want to leave anyone out. But the interesting Keegan and Tallez implementer-led Frand action that's quite new. But the two that I think probably merit some mention now are what was said by the Court of Appeal in Nokia and Oppo. So you've had this decision where the Supreme Court in Conversant and Unwired Planet left open the forum question to a degree, and that's now sort of been roundly answered in the Court of Appeal, where it was concluded there's no natural forum for a Frand dispute, so England is as good a place as any to get on with it. So that sort of put most of the forum aspects to bed. And then you've had a long, hard-fought battle, I would say, by Optus and Apple, where we've reached the conclusion that you need to give an undertaking to enter a Frand license on liability being established. So when you've got a valid, essential and infringed SEP, you now need to give an undertaking. And that didn't happen in this case for a couple of reasons we'll come on to, but it's now crystal clear that that's really the law. And of course, we're all eagerly awaiting yet another rapid reaction, no doubt, to the Optus and Apple Frand judgment. But that's the sort of background to all the jurisprudence, which has led to certainly all of us, I'm sure, being tucked up in bed reading some nice Frand judgment with a cup of tea every evening for the last week.
So then going into this trial, in terms of what the parties' positions were, obviously Interdigital had succeeded in having patent upheld, and so in theory was entitled to an injunction. As Luke said, an injunction wasn't in fact issued at the point of the final order hearing on liability, but the case would, and Lenovo hadn't undertaken to take the Frand license at that stage that would be determined by the court. So the focus of the case was really then upon two issues. One, what were the Frand rate and terms, and then secondly, what was the Frand, what should the injunction position be? So in terms of the offer that the court was sort of adjudicating on, the parties had expressed their offers both as lump sums, but we'll unpack those a little bit in a minute. So going into trial, Lenovo's offer was 80 million euros, dollars rather, and that was for both the past and the future. I think the past ran back quite a number of years, and the future actually doesn't go very far into the future now, because the term of this license will expire at the end of this year. So Lenovo was at 80 million, Interdigital was at 336 million. And so then the point for trial was Interdigital's offer, which embodied that lump sum Frand, and if not, what terms were Frand. So as I say, the term they were essentially talking about was the past prior to January 2018 and 6 years forward from that. Interdigital's rates were, I won't give you all the rates, let's focus on 4G because that was kind of at the heart of it. So the 4G rate, it was based on an ad valorem rate of 0.45%, but that was subject to floors and caps, which actually don't get discussed that much in the judgment, but anyway, but we think that translates roughly on to a range in dollar terms of 0.23 to 0.90 cents per device. And there were various specific discounts for prepayment and so on that were part of that. And Interdigital kind of expressly said that corresponded to its program rates.
Yes, and on the other side, you've got Lenovo's lump sum of $80 million. That requires a little bit of unpacking. Actually, they concluded in their skeleton by saying that they were offering $80 million, but they had a plus or minus 15% tacked onto that to reflect the imprecision in unpacking to a blended rate for past and future. The way I'd sort of interpreted that is that they were saying the Frand range fell within those brackets, albeit that's not expressly said by Lenovo. That derives from, as a midpoint, that offer level, where they did one calculation that resulted in a $65.4 million offer, and another calculation that resulted in a $99.6 million, and they were quite open about the fact they'd just taken the midpoint. One was a low rate for the past and a high rate for the high-ish rate for the future, and the other was a blended rate. And that was for sales in a 6-year term with a full release for past sales for no consideration, which is expressly what the offer was. And in terms of going into the actual meat of it, everyone agreed with doing a comparables analysis. Interdigital wanted to do a top-down analysis. Lenovo said, well, that's not very useful on the facts of this case for reasons we can get into. And then the focus really was about whether the Interdigital 20, as they were named, the 20 licenses Interdigital wanted to look at were the right ones, or the Lenovo Big 6, later the Lenovo 7, were the ones to look at, with the obvious split between those, with Lenovo wanting the Lenovo 7. So next, determination of a Frand rate. High level points, because I don't believe in holding spoilers till the end. So basically, no one's offer was Frand. That's what the court found. No one's offer was Frand. What was Frand was a rate of $0.175 per device. The court agreed with the 6-year term ending on the 31st of December 2023. So looks like we could be back soon. That's going, though, back to 2007, which is a very interesting point we'll come on to talk about. And based on Lenovo's sales data in that period, that's a lump sum of 138.7 million. That's a blended rate, based on a blended rate for all sales, past sales paid for in full. And there's a question mark over whether interest is going to be awarded by the court, which has been helpfully held over for the final order hearing on a date to be confirmed. But in theory, they're supposed to be within a month of hand down, so hopefully quite soon.
Would you mind commenting a bit more on the Frand royalty rate determination and Frand valuation, please?
Yes, of course. So obviously, it's the comparables issue that is most interesting here. It's very much the focus. We will talk briefly about top-down a little bit later, but for now, the court had to give quite a lot of detail on the comparables analysis. And I think perhaps Mr. Justice Mellor did address this slightly more at the level of principles than Mr. Justice Burse in the Unwired Planet decision, not least because here he was faced, Mr. Justice Burse had to deal with the question of relative value of the Unwired Planet portfolio to the Ericsson portfolio, which has been carved out from. Whereas Mr. Justice Mellor had the luxury of having a large number of licenses in front of him that related to the same portfolio, albeit over time. So his key takeaway on how to approach the unpacking is that the analysis should be objective. So what the court is not interested in, at least at the high level approach, is the subjective view of the licensor. And so that led, I think, to some of the kind of ways in which he then analysed the evidence from the parties, and I think particularly from Interdigital, where there was, I think, some measure of discussion over whether Interdigital's expert report, for example, was too much focused on saying why the licenses supported the program rate, rather than doing a more kind of first principles analysis of how the rate should unpack. And I think he at one point described Interdigital as going for the jackpot rather than kind of seeking to find a more middle ground position. And I think there's a really strong trend in all of the English cases now, from Mr. Justice Burse through the Supreme Court to this case, to say that Frand is about a balance between hold up and hold out, navigating between those two extremes, seeking to find the middle ground position. And I think this is an indication that the court really wants the parties to be seeking to do that more, rather than adopting the sort of potentially extreme positions. And I should say, I don't think Mr. Justice Mellor, he didn't characterise either party's position as extreme in most respects, but I think he did say that middle ground was somewhere they could have pushed a bit more towards.
What are the criteria for comparability? What did the court consider comparable license and what not?
So yeah, so going to come on to that. I think what I was going to just talk about briefly was quite an important issue about how the unpacking was addressed, which relates to the question of how discounts should be applied. If that's okay, I can make a start on that before we get into the core issue of comparability. So I think the question over discounts comes out of two places. One, out of Interdigital's program rates, which incorporate volume discounts. So the more units you sell, the lower the incremental rate for the units beyond a certain level. And that's obviously something that is kind of quite classic when you're talking about sale of goods, where there will be efficiencies in terms of selling larger volumes. But Mr. Justice Mellor was quite skeptical about that when applied to IP licensing, where there isn't any real incremental cost of each additional licensed unit in terms of the IP license. And the other way the discounts were considered relevant was because of the way that the particularly Interdigital's expert had sought to retrospectively apply discounts or gross up for assumed discounts in relation to the unpacked royalty rates that he was assessing. So the Interdigital evidence suggested that they had applied a range of discounts. There was the volume discount I mentioned. There were also discounts for payments of lump sums, discounts relating to the time value of money. So in terms of, if you're getting all of your royalties up front, then there will be a net present value type discount. There were some discounts for regional sales mix and for renewal. So some licensees had gained a renewal discount when they renewed either before expiry or shortly afterwards. Mr. Justice Mellor wasn't very persuaded by many of those discounts. I think it's fair to say the only one he thought was objectively justified or clearly consistent with Frand were the ones that related to the time value of money. He was particularly skeptical and spent most time on the volume discounts issue, where he actually took quite a strident view, I think it's fair to say. And I think partly driven by the fact that the discounts were really quite significant on an incremental kind of unit basis. So he made clear that he didn't think any volume discount would be out of the question or inconsistent with Frand, but he made quite clear that he thought Interdigital's volume discounts were inconsistent with Frand and risked discriminating against smaller licensees who were paying much more on a unit basis than the larger licensees. The other issue that he had to consider in this kind of points and principles part of the, before he got into the detail of the unpacking and comparability, was the question of past sales. And so one approach that we you even see Lenovo taking it in the relation to their offer. They had suggested that one of their calculations used a lower rate for the past than for the future. And Interdigital's expert had done something similar by saying that when unpacking the licenses, he was attributing a kind of full rate, if you like, to the going forward sales from the point at which the license was entered into, but a discounted rate or no rate at all for the past. And the court was very unhappy with that approach and said that there was no justification at all for discounting past sales. All past sales should be paid for, and at the same rate. And what's more, it wasn't just all past sales back to a sort of nominal starting date that was consistent with limitation periods. The court said that the limitation periods have no role in the relationship of a willing licensor and willing licensee. A licensee, to be truly willing, has to be unconditionally willing and should be willing to pay for all use they have made of the licensed IP. And so therefore, in a Frand context where the court is setting the terms of a Frand license, there wasn't any need to say that the past release should be limited by reference to limitation periods, which can differ by country. Rather, the license, if it's the first license a party is taking to the portfolio, should go back, cover the entire past at the full rate. So, when we come on to talk about whether this judgment is pro-licensee or pro-patentee, that's quite an important factor to take into account in terms of, the patentee's position in particular. Just a couple more points on these kind of points of principle issue. I think the judge also kind of was a bit concerned that some of the unpacking analysis didn't take into account some of the other things that were going into these licenses. So the parties were very focused on the value of the cellular handset patents, but didn't take so much account of non-handset licensed products, so tablets and so on, or of IP that was not the cellular IP, particularly the Wi-Fi and HEVC patents, as well as non-essential patents that were also licensed. And the court, this is where one of the courts sort of said that you shouldn't take the subjective view of Interdigital into account. Interdigital had indicated that it was really the license negotiations were all about the cellular value. And the court said, well, that's as maybe, but when you look to see what market value you derive from these licenses, actually there is a value for Wi-Fi and HEVC, for example. And based on the party's evidence, he calculated that that was roughly 13% for those smaller standards. So that's a bit of a sort of overview of some of the points of principles. And I think, Miles, if you've landed in the meeting, I think it was over to you on a bit more on the comparable license analysis.
Yes, thank you, Sophie, and apologies everybody for not being able to join at the beginning of the meeting. Yes, so I think we've probably already said that to an extent there's this battle going on in the judgment between what was called the Interdigital 20 set of comparables and the Lenovo 7. And Luke, have we done the 7 samurai joke?
No, I left that one for you, Miles.
Okay.
Thought it was.
We had a discussion. Was it mean 7 exactly? But so to have to choose between these different approaches from the two different parties, and I think, as we've already said, he probably felt that the parties generally were quite polarized in the positions they were taking, and that made his job in some ways more difficult because he had to choose one or the other, and there wasn't a middle ground being given to him. But when it came to the comparables, he looked at what IDC said, and he said that basically the licenses they wanted to rely upon were mostly those were to smaller entities that had been something ultimately close to the headline rates, the program rates. And he found that, as against Lenovo, that those weren't good comparables because those were different kinds of entities. IDC's fallback case was relied on the LG license, which in fact he ultimately concludes is the best comparable. But there he didn't like the way that they'd unpacked it. And the reason he didn't like it was because he felt their evidence took a subjective view. They'd unpacked it, going, well, this was the view that IDC took about what was likely to happen, how many units were likely to be sold. And he thought that that sort of hindsight analysis was not sufficiently objective. So IDC's comparable submissions didn't get a lot of traction with the courts. And he therefore is relatively left with the Lenovo 7. And he notes that felt to him particularly compelling because the licenses that Lenovo had identified amounted to something like 97 to 98% of all the units that have been sold globally. And so he's going, okay, well, this seems to be the right basket for me to be looking through. And in the end, he goes through those and he says, makes views about the circumstances in which they were negotiated, which I think is interesting because, as we've probably touched on and we'll talk about later, in some parts of this judgment, it feels like the judge is saying there should be, I'm going to come to sort of one rate and there's one objective rate which everybody gets, and I don't like discounts, and I'm trying to find a single point that everybody should be entitled to, which seems somewhat different to what was said in Unwired Planet. But in fact, I'm not sure that's entirely right. What he doesn't like was the way discounts were used to try and back out some mathematically correct figure that can then be readjusted with other discounts for a given entity. He doesn't like that. But what he does accept is that you're entitled to look for what is the best comparator to the entity that wants to be licensed. And I can select from everything that's gone before to find the one that is the best comparator. And I think that's interesting because it shows that there is still scope for negotiating, for having different arrangements with different kinds of entities. This is not a one-size-fits-all approach that he's really mandating. And through that process, though, he says, I think the best comparator in terms of volume, in terms of sales mix, in terms of the mix of technologies was the LG license. And so ultimately what he does is he takes that LG license, he makes some adjustments to allow for what he sees as Lenovo's particular place in the market, its volumes and its regional success. And that's what he uses as the basis for his core findings about the Frand license. And I think, and then I was going to, and then at that point over to Luke, I think.
So I was just going to add one point, if I may, just to say that although he does focus very much on the one license in the end, and he makes adjustments based on that to reflect different geographic sales mix, I think it's fair to say that he also thinks that a number of the other licenses do support that rate. So, he sort of made observations about certain of the licenses that perhaps were a bit lower than a Frand rate, but he also noted a number of others that were very similar, came out at very similar rates. So I think although he's focusing on one specifically, I think he, and this is perhaps a bit implicit, he did take confidence from the fact that other rates among the Lenovo 7 supported that rate.
Yes, indeed, and made some comments about Apple as well, having a unique status in the market. So there was some interesting stuff he said about the various comparables. But I was just going to touch on holdout, which as a word, if I got a penny every time I heard it, I'd probably be retired in the Caribbean by now. But he does have a detailed analysis of whether the Lenovo 7 were the result of holdout, because that's effectively the natural means by which you might seek to exclude them from consideration as comparables, or certainly as exclude them as evidence of what the market is willing to bear for the portfolio in question. And he was particularly critical, not of the approach Interdigital had taken to marketing licensees. He said that was an entirely fair approach, and it was just a symptom of the market. But he was critical of the fact that he had no evidence in front of him saying that he couldn't rely on the Lenovo 7 as comparables. It hadn't been suggested that in sort of detailed evidence that they were unreliable comparables because they were the grounds of holdout. And then, of course, as Miles said, he makes the point that there wasn't a middle ground case for him to consider. So there's a factual basis there where he sort of looks at the Lenovo 7 and says, well, that's what 98% of the sales relate to. That is effectively 98% of the market is paying this, and I don't have evidence in front of me to suggest that those licenses are not appropriate comparables because of holdout, which is another reason why he focused on them. There's also an interesting point from Mr. Justice Mellor where he notes that there's nothing shifts an impression he had originally that he then settles on, and he has nothing to shift him from the position that in his view the economics of securing a license with big parties, actually he can't see why there's no economic incentive to litigate to get a higher rate if you're going to spend £5 million on a UK Frand determination, but even if you move the dial by 0.001%, that's worth $50 million. The economics there actually support pursuing that. So, but with all those in mind, that sort of informed his focus on the Lenovo 7. And then on holdout more generally, though, he was extremely careful to make sure he was making absolutely clear that the English court is keen to basically reduce any incentive to hold out. There should be no reward for delay. And Sophie touched on the limitation periods. His view is you get full payment for past sales, which of course, negotiated licenses often don't have full payment for past sales, as we all know, and as you can see, but you have to pay in full. There's also a query if interest might be payable. That's a sort of watch this space. And then the final point, which I think, Miles, you were going to mention very briefly, is the court is embracing its involvement in the ecosystem. Is that the best way to put it?
Well, absolutely. So yes, it's one of the things I find most interesting about this judgment is, and I've often thought that the only thing that's as complicated as Frand is possibly quantum physics, and I feel that it's this aspect where quantum physics comes into the judgment, because in the Schrodinger's cat experiment, it was all about if you open the box and see what's happening, then you influence events. And that's absolutely what Mr. Justice Mellor is doing here. And he says it in terms. He says, all these things have happened in the past. I can see the negotiations that have led to these agreements. But I think those negotiations were flawed because the marketplace didn't have access to the kind of judicial solutions it has now. And so therefore, it was an imperfect process. And this point about the past sales is a good example of that. He's saying, well, people used to discount, I can see there's rates being agreed here because people have discounted what happened in the past because they thought the Limitation Act problems would stop them recovering from it. And he says, but I don't think that's right because I'm going to treat it as different. It's not a damages issue. So there isn't any limitations. This is what would parties have agreed to license the technology, and that should run from the point the technology is being used. And because he says there's this historic imperfection, therefore I'm telling you now that doesn't need to be the case, and I can see in the future that will correct itself. So he's very expressly inserting himself into the ecosystem and influencing it and saying this will change things in the future.
But I think it's also fair to say that I don't think he sees himself, or certainly himself, or the English court as having a unique role in that regard. He's very open to the fact that there are other courts who will be also opining on global rates and having a similar influence. I think probably the thing that is a bit left open, though, is what happens when those courts disagree and take a very different approach to things, because where they're all determining global rates, then obviously that then creates a real problem in the market as to how do you navigate those competing findings if that is indeed what happens.
He does have quite I completely agree, but he has quite a Pollyanna optimistic view that it's very much, he accepts that this is not just a thing for the UK court. This is all the courts around the world may well be grappling with this, but he in a number of places says that body of growing global case law is really going to help things. We'll all know where we stand. So, but you're absolutely right. In the meantime, while that leveling out process is taking place, it's difficult for the market to understand, what the best strategies are.
And just becoming a little bit less metaphysical for a moment, I think
Wow.
one of the things that comes out of what you're saying about how the court was going to award the same rate for all of the past and all of the future, it is that one of Lenovo's sort of points that it advances, well, that's discriminatory because Interdigital has often entered into licenses that do have a discount for the past. And so why should I pay more? But I think that is the very reason why they're paying more, is because they are before the court, they haven't managed to enter into a license. Now, query how you square that with the fact that they were, according to the court, never offered a Frand rate, but nevertheless, that is his view. And so I think that, you know, although there's not a great deal of discussion of the kind of Supreme Court and Burst's benchmark approach, Justice Burst's benchmark approach, I think the way that he's dealing with the issue there and the fact that you don't get discounts for the past is very reminiscent of that benchmarking idea.
Yes, and I think at some point he does make a comment in the judgment that effectively by licensing 98% or thereabouts of the market at around about a particular rate, you know, that there comes a point at which one is setting a benchmark, not having a few outliers that may be subject to holdout. So again, he does touch on the benchmark from the Supreme Court from that sort of point of view. But I don't know, Roy, if that's a good roundup of the comparables analysis.
Thank you very much. Sorry for being a bit like one-sidedly interested. I see we have so many questions still ahead of us, and we're running out of time for that discipline. But so I don't know. I mean, we have other issues around injunctions and injunctive relief. But I don't know, Sophie, if you would like to comment on other things, please do.
I was probably just going to say very briefly on top down. I mean, I don't think we need to spend long on it because the court doesn't spend long on it, and it doesn't find it useful in the context of this case. I think it's fair to say that the court doesn't completely dismiss the idea of some form of top-down analysis as a cross-check, which was what was done in Unwired Planet. But the court doesn't find that both of the forms of top-down analysis were put forward by Interdigital, and the court didn't find either of them useful. I think they were too heavily dependent on a number of assumptions, and the court was particularly critical of the more sort of novel analysis based on a hedonic regression analysis, which as I said in the email.
Oh, you won't get.
I'm not going to attempt to explain it because we'd be here for a long time, and I probably wouldn't do a regular of it. So I think the one thing I would say about top down is that he did find it useful to know what other courts had found to be the approximate aggregate royalty for particular standards. He does find that useful, and to me, somebody who advises companies who are seeking to negotiate Frand licenses or thinking about, well, how do we support our Frand rates or our Frand proposals in litigation, I think that's a very helpful point, because there can be a tendency for us as lawyers to say, well, you have to prove every fact that you want to put before the court. But I think the way of thinking about it, which seems to be the approach Mr. Justice Mello has taken, is that in the world where people are sitting down and seeking to negotiate these licenses, that information is part of the information they're using to reach those conclusions. And so in that context, it's completely fair enough and reasonable to look at that kind of information.
Yes, and there's probably not much to say on injunctions either, actually, Roy. Just to touch on, as we mentioned at the start, the Frand injunction, he sort of corrected himself or corrected the English court in a small way by saying that with hindsight, the Frand injunction election should have been put earlier. And I think it's pretty clear now that on liability being established for valid essential SEP, you will have to take the English Frand license or face a Frand injunction effectively. And I think that's now been he sort of cleared up the fact that didn't happen in this case as something that was a bit of an error that ought to have gone the other way. But similarly, he reinforced the fact that the idea that you're entitled to an unqualified injunction is unreal. And he does make a small comment saying that actually on the facts of this particular case, Lenovo were justified in saying no to the offers that had been put to them. I don't know if it's worth just touching on willingness very briefly, Sophie.
Sure.
Can I ask you also, I think there's also a debate about the willingness of the licensor, which seems to be a novel concept. And quite interesting. So willingness of unwilling and willingness on both sides.
Yes.
Yeah, so I think nobody was willing, according to Justice Mellor. I think I think willingness of the licensor has always been there to some degree in Huawei and ZTE, which is actually interestingly the only time the court refers to what is really the leading case on the kind of Frand dance is to say, I'm not going to talk about it. What I think is particularly interesting about this case is the way in which the level of the rate that's being offered is now seen as a factor of willingness. It isn't just a kind of formulaic, here's my patent, I'm going to keep talking to you at regular intervals. None of that really mattered. What mattered was the fact that the parties hadn't made Frand offers during the negotiations. And in particular, I think, the Interdigital hadn't made an offer that Lenovo could accept as being Frand in Mr. Justice Mellor's view. And so I think, the net result of all of that discussion is that the only thing that really matters in terms of willingness is the licensees needs to have an unqualified willingness to take the license that is being set by the court. Otherwise, once there is a patent infringement or finding that the patent is essential and infringed and valid, then they will be subject to a Frand injunction until such time as they take a Frand license. So that, I think that was what we expected to be the case after these judgments, and particularly in the light of Lord Justice Arnold's opinion in a case name that's temporarily forgotten to escape my memory, but towards the end of last year. I think it's fairly clear now that that is the position going forwards, and licensees are going to be very well aware of that.
Yes, and on the particular topic of the licensor's willingness as well, he did pass comment that in his view it wasn't Frand, nor is a licensor acting as a willing licensor, to refuse to provide the information necessary for a willing licensee to evaluate an offer that's been made, and that includes third-party licenses. And I think that's kind of quite an interesting finding in itself, and I think brings us on to Miles. You were going to just talk about some of his postscript on case management. Postscripts are becoming awfully common in Frand judgments now, I've noted. Yeah,
I think that, yes, it's the new black for judgments, just to have a bit of a postscript, just one more thing. It's interesting, and I mean, we've all been waiting for this judgment for a long time, having seen it and ploughed through it, the 225 pages, almost 1,000 paragraphs. I think much more sympathetic now to poor Mr. Justice Mellor, taking that time to go through the information. So it's perhaps not surprising that he is saying, I think there must be better ways of doing this. And I think, the big point that he found particularly frustrating was that the parties were somewhat ships in the night in their approaches. They just took different approaches to how they unpacked anything. And in particular, the two experts used completely different data sets. So he found that even when he was trying to adjust, well, I don't like this aspect of the unpacking, but I'd like to compare how that goes with what the other experts said, it was almost impossible for him to do so because they just used completely different data sets. And so he says, in the future, that's an example of the kind of thing I think the court should be much more active through the course of the proceeding, to be in a dialogue with the parties at a much earlier stage, to say, what issues are we actually going to resolve and how are we doing it? What are you going to ask the judge at trial to actually look at? And so to that end, he says it would be great if they use the same data sets. And I think at what we call the pre-trial review, which is, happens in advance of the main trial, that should be a more significant exercise where the issues that are going to be talked about are actually put on the table while there is still time for the court and for the judge to say, that's not going to be efficient. I mean, there must be a better way that we can do that. So that was, and I think what he's hoping is that we won't have to have such mammoth trials, such mammoth judgments in the future, if that can be more actively managed. And then the whole process becomes of more use, hopefully, to the participants in the system.
Yeah, and there's a sort of active call out as well, isn't there? An active reminder that we've got a good, we're used to Frand cases in this jurisdiction. We've got a good body of jurisprudence, particularly focused on confidentiality, with a sort of well warn disclosure regime, where, you know, no problem, start a UK Frand case, and disclosure can be used to potentially help the parties settle the dispute, so we don't actually have to have an actual trial. So it's sort of,
and I think that's absolutely right, and there are perhaps indications in what he says that this may not be something that just one side of the debate wants to take advantage of. You know, if either side of the debate, as you pointed out, he finds that IDC's rates during the negotiations were probably, in his view, not Frand. So I think what he's laying out is a scheme whereby if somebody's in that position, if they're in Lenovo's position, they want to take a license, but they don't see there being offered rates that seem sustainable, and they also don't understand what the basis on the rates that they're being proposed, because, as he notes, one of the main preoccupations of people who are interested in taking a license is that they don't want to pay more than their competitors, which is absolutely what the way things should be. But outside the constraints of this litigation, when then you get to see what the competitors, through under appropriate terms of confidence, if you're just without that mechanism, it's quite difficult for the parties in the wild. So I think that's his purpose here, is to say maybe there is a more streamlined way that courts, not just the UK court, but other courts potentially, can help the parties come to that kind of greater degree of transparency as between the two of them.
Yeah, well, whilst making the point that this is not a most favoured licensee approach by any stretch of the imagination.
Yeah.
References to other jurisdictions in terms of how, any comments about Frand cases from other jurisdictions, about the German approach, for example, to what constitutes an unwilling licensee?
Not so much Germany. I think he looks at some of the judgments, like in particular, he makes a number of references to Judge Sellner's TCL and Ericsson judgment, in full awareness that it was obviously, not regarded as being procedurally proper, but when it went on appeal. And he also makes a number of references to some of the Chinese cases. And I think it's also worth noting that he points out that when this case started, I think it was still before the Chinese court had undertaken a global Frand determination. So, we will probably still see more influence of those sorts of decisions coming out of China, and a sort of feedback loop, perhaps, in future cases.
Yes. Yeah, I think there was one mention of Sisvel and Hire in the judgment, and it was Mr. Justice Mellor suggesting the Chinese court might want to consider it, which is a sort of slightly interesting, sidebar. So otherwise, though, I suppose there's just the minor point that we all went into this judgment thinking, oh, there's going to be some interesting case law about what we do with plugging in foreign rates, and the foreign rates sort of section is, I've read the expert reports on Chinese and US law, but I don't have to decide anything to do the justice to the actual issues that are in trial. So I suppose those points are slightly left open.
Yeah, and of course,
I think that was largely because the way the arguments between the parties fell out.
Oh,
At
exactly.
the time we got to trial, he wasn't being asked to do anything with anything from another jurisdiction. So he said, well, this is interesting, and I've read it with great interest. And I think the parties didn't call any of those experts to trial. So he didn't see any of that. He was just given the reports to read later on by way of homework. And he says, well, I read them, and they're very interesting. But nobody actually asked me any questions that seemed to turn on them. So there we go. But I think, just building on what you said there, Luke, that he does definitely, there's a thread of respect for other jurisdictions, that there will be determinations from other courts, and those could well be very relevant to what the English court is doing going forward.
Yeah, and I think the other thing I was going to mention was that obviously by the time when the draft judgment was published, at that point Lenovo did undertake to take the license that the court had determined, subject to the outcome of any appeals. So I think, to the extent that there are overseas, so I think there were proceedings in the US and perhaps China in relation to the past as well. I think those kind of largely fall away because the court, Lenovo, has now undertaken to take this license. I think there is still a global determination pending in China for the future rate.
Yes, well, I suppose that's from 2023, 31st of December 2023, 2024.
So is this pro licensee, pro licensor, somewhere in the middle? What's your take? Which
Yeah.
who's winning in this, or both winning?
So I think it's just, maybe some initial comments, and I think others will pick up, but I think certainly, some of the sort of chat initially has been, this is very favorable to implementers, and I think that's probably driven by the fact that, or by the licensees, probably driven by the fact that the rates come out much nearer what Lenovo is proposing, in circumstances where Lenovo had obviously for many, many years resisted taking a license. But I think actually our reading is that it is much more balanced and very in line with where the court has come out before, which is a system that patentees have liked to use in order to sort of reach Frand determinations. So patentees still have that ability to come to the English court to seek a determination of the Frand terms, which will result in a license being, either sort of agreed, if you like, or under the shadow of an injunction, or unless the licensee is so unhappy with it that they're prepared to leave the English market instead. And I think, the court kind of focused on this idea of unconditional willingness by the licensee, and as we said, as discussed already, they have to pay for the full period of the past. And the interest point, which is still outstanding, that could also be another sort of significant milestone or significant factor in favour of the patentee. So I think we think it's actually very balanced, and a lot of the reasons why the Interdigital rate came down was very specific to the particular way Interdigital's program had been structured and set up, and the particular evidence that was presented. And as we've, you can tell from the difference between On My Planet in this case that the evidence is so critical. You're not going to get another case that directly mirrors this or how it came out. Ultimately, each case will turn to a significant degree on its own facts.
I completely agree with all that, and I think although the way the numbers fell out, as Sophie says, ended up being more towards Lenovo than the midline between the two parties, it's clear that what he wants to do is to find, well, what is a rate that you, the licensor, have been happy to give to somebody who's basically the same shape as the person we're talking about now, and I think you should be entitled to get that rate, and that rate should go all the way back to when they first started using the technology. And it's not that he's saying a most favored nation approach, because when he's doing his comparable search, he's very much saying he looks through all the different licenses, and where he finds reasons why this was a deal that was done in particular circumstances, he says, so I can see why the patentee entered that deal, but I think it was particular to those circumstances, and so I'm not going to hold them to it now. That isn't a good comparable. So I think he's very much trying to find what is a fair and balanced solution as between both parties.
That was my impression too. That was my impression.
Roya, we see there are some, we haven't looked at them, but we see there are some Q&A.
I looked at them quickly. It's like a lot of questions and a lot of other questions. I think some round short comment, which I'm paraphrase here, is Justice Mellers, this is an excellent presentation, I agree, that he could probably only just write it in the UK because he isn't faced with the choice of having to present evidence in the US, the US jury.
Yeah, interesting perspective.
Then there's a question: has any thought been given to the role of on sub-licensing and relative rate setting if the facility was embodied in the license terms and their sub-licenses controlled by Frand?
I think the short answer to that is no.
Yeah.
I don't know whether this is got a sort of flavour of what happens in, for example, the automotive market, where there's a much more of a question over the level of licensing. And I think again that that this judgment doesn't deal with that.
Does not happily go down that route. Is it reasonable to infer from the court the view that by making a SEP declaration, a patentee is willing to offer a license that the court finds just, equally that a party that infringes on a SEP patent, that the party is willing to honor whatever license the court finds just?
Yes, I think the answer to that is probably yes. The court is saying if the parties can't agree between themselves, if you come before me, then I am going to find what a Frand license is, and I will expect the patentee to offer that license, and I will expect, as Luke was saying, I will expect the product innovator, the licensee, to take that license. So I think it's saying once you give that commitment and once you get into the court process, that's what the court's going to do.
There's another question on the discounting payments due for past sales is clear, okay. But does it refer to the entire portfolio of patents that were used or just to the ones in suit?
It's all about the portfolio. The court specifically says the ones that are in suit are completely irrelevant to this analysis. The only reason the patents in suit are relevant is because that's what gives you the lever to the Frand injunction, assuming as the patentee you can get one to stand up.
Okay, we have 4 minutes left. What would be your, I know we have a few reserves questions, but what would be really your key takeaway from this? From a competition patent perspective, from a big picture perspective, like the punchline?
I think it's, right, sorry, Sophie, you go if you.
No, I'm waiting for you to give me the punchline.
We insist, Miles.
The punchline. I think that the punchline is that Frand can be determined outside the kind of the wild, parties negotiating laterally. There is although it's difficult for courts to engage in, it's possible. This decision is another template showing how the courts can engage with these kind of questions. And it feels to me like it's been written as a path. We've had Unwired Planet that set out the basic concepts, and this is me developing and showing how things may improve in the future. And I think Mr. Justice Mellor sees this as a path to a more rational way for parties that can't find a path as between themselves to negotiate, that there's a route forward for them.
And I suppose the other thing that's of interest, I'm not sure whether it's the punchline as such, but is the discussion of transparency in more general terms, and the kind of encouragement he sort of suggests towards measures that will increase transparency. So, for example, when you're drafting your licenses, you would like to see recorded in them, if it's a lump sum license, well, what were the factors that influenced that? What sales were assumed? What rate was assumed? I have to say, I think that would probably hold up concluding negotiated settlements if that was required. And I wonder also what is going to be, how well that meshes with what the European Union is planning to propose in its regulation. I understand is due to be published at the end of next month.
I mean, Mr. Justice Mellor, I think, would like to make things simpler in terms of the analysis, wouldn't he? He doesn't want, he's saying, really what I'm interested in is what did you pay? How many units did it cover? And then we'll look at, regional distinctions and things, but that's it really. He doesn't want to, if he can, get too embroiled in this kind of discount, that kind of discounts, lots of advanced economics. He's trying to say that this should be fairly straightforward. Whether he's right or wrong about that is, remains to be debated.
Do you think, what's the effect in your personal view? I know you litigate this, but what's burning on me is like UK competitiveness post-Brexit. I had a chat yesterday about this with people in British government, and we talked about it at length, and we had a view on that. We thought it's probably good for British economy. We're not sure it's the best for the British litigation profession. What's your take on that? And will we be competitive if the Unified Patent Court offers a pan-European injunction with in reach for patent infringement, and we have a judgment in the middle ground? Will we attract litigation? How will this affect local businesses, etc.?
There's a whole, obviously, another hour, several hours of debate that we could start about that, Roy, but it's a good question. I mean, for me, it's interesting that what this shows is how this is a really complex issue, but it can be dealt with. I'm not sure that with things like the UPC system, it's going to be so interesting to see how are they going to deal with this, because is the patent valid? Is the patent infringed? That's relatively straightforward, and obviously UPC can make that finding throughout the contracting member states. But then what's it going to do? How within its structures, its mechanisms, its very fast, very streamlined procedure, is it going to come to a fair resolution of, but in this case, should there be an injunction or shouldn't there? Because what you see in this judgment is Mr. Justice Mellor saying that question, should there be an injunction, shouldn't there, absolutely turns on who was being fair and not in the negotiations. What is Frand? Was Frand offered? Was Frand not accepted? And you can't answer that question unless you work out what Frand is. And I think that's going to be the challenge.
This is.
But that's going to be the challenge, I think, for if you have a system that doesn't readily let you get into the detail of, well, what is Frand and who was wearing the white hat and who was wearing the black hat, how are you going to fairly make those decisions?
And the English court has always been proud of the fact that it resolves disputes. That is what it is there for. And however those disputes get resolved, it is great. We don't need to have a trial. And he advances this point, and I just don't necessarily see the UPC is going to be in the same position, that we shouldn't be just getting to the point of an injunction and going, yes, no. You know, he's saying we've got all these mechanisms, we've got confidentiality regimes, we've got early disclosure, we've got pre-action disclosure. You know, these are all tools that can help parties using the English court system resolve their dispute themselves without necessarily getting to trial, by getting the information they believe they're lacking. And he's very clear on promoting sort of those aspects so that parties can kind of help themselves as well.
Yeah, and I think that kind of process, I think it's already been something that we've seen. You know, there have been a number of previous Frand cases that have been started, particularly since On My Planet, which haven't gone to trial. Obviously, we have in the last year seen the 2 trials where, you know, the parties obviously still have felt that there's enough to argue about and to ascertain. But I think it's pretty clear that the process of going through a Frand litigation does enable parties to actually settle what presumably then they're at a level that they're presumably both reasonably happy with.
Fine. Good. Now, Dennis, with all of this being said, this was an excellent rapid emergency intervention, so we know what's going on. Thank you for reading a judgment for us. Yeah, great. Thank you very much. Very insightful. In any case, we can for sure say this is an extremely well-prepared judgment, where a lot of thinking went into, which was not written over the envelope, and which is fair. And yeah, great contribution. Let's see where Frand goes forward. Yeah, again, please, if I may say, Oxfuse 8 IP and Competition Forum, 8 IP and Competition Forum, Brussels, June 20 and 21. Please come. Christos is a sponsor and great ally in this whole matter, as many other people in policy circles, the judiciary and industry. Please do join us if you're interested. Please come to my conference.
Looking forward to it, Roya.
Thank you very much for putting this together. Very, very insightful. We'll try to get this out quickly now. Thank you. Bye-bye. Thank you for joining us. Bye-bye.
Bye, everybody.